like to call the Rules and City Government Committee meeting to order. I apologize, we had some other business, and so we're starting 30 minutes late, but we're ready to go now. I'd like to note for the record, the members of the committee are present, Alderman Arnett and Alderman Chandemeyer. We're also joined by Alderman Savage and Alderwoman Pindell Charles. I will now entertain a motion to approve the agenda as written.
So moved.
Second.
All in favor, please say aye.
Aye.
I will entertain a motion to approve the minutes from the February 2nd meeting.
So moved.
I cannot second because I was not present.
Okay, I can second that. All in favor, please say aye.
Aye.
Aye. Okay, election of chairman pursuant to City Code Section 2.16.120. I'll open the floor for nominations for chair for the Rules and City Government Committee. We didn't have this discussion.
I nominate Alderwoman Finlayson.
Second.
Okay, no one else is interested, I guess.
Oh, I want to be desperately, but I don't have a committee.
Thank you. It's been moved and seconded. All in favor, please say aye.
Aye.
Okay, thank you. And I've made this statement at other committee meetings, and I'll make it again. I'm looking at proposing legislation that will force the rotation of committee chairs every year so that everyone's experiences get utilized. So just want that out there. And as I said, I've made that statement at all other meetings that I've participated in. Okay, going on to legislation. 03223, short-term rental licenses and regulations. Alderman Savage, I think you are the lead sponsor on this. So do you want to walk us through your changes? You know, we have labored with this for a number of years. So tell us what you're doing, trying to do now with this ordinance.
Well, so I guess I could start with summarizing the last meeting we had. We had staff come from planning and zoning and code enforcement, and they did express, I think, their support for the legislation, as well as the Savage Amendment 3, because they saw it as strengthening the code and strengthening the original intention from your ordinance a few years back. And so what we got through at the last, I believe from the last committee meeting, was that the committee, I think, took action on the underlying, or finished discussing the underlying ordinance, but had not gotten to any of the amendments. And so in particular, you know, the underlying ordinance, the goal was to just tighten the licensing requirements, to clarify that only a person can only have one short-term rental, and making sure that we don't have random LLCs and multiple owners trying to get around our one owner, one license rule. And yeah, that's basically what and then at the same time, staff rewrote it to make it easier to implement. And we went over a comparison of the legislation as written compared to the code to make sure that we didn't lose any of the existing content. And I think Ms. Ruther put together a document that showed that. So, Madam Chair, I think if you want to discuss any of that again, we could do that. My request, I guess, would be to perhaps start with the O'Neill amendments 1 through 5. 2 from O'Neill, 2 from me, and then 1 from Alderman Arnett.
If it's okay with the committee, we can go straight to the amendments if there's no further background needed. Alderman Arnett?
I thought we had actually gotten well through the Amendment 3 from Alderman Savage with the help of John Manessa. I didn't mark on my copy that I'm writing on which amendment we stopped with, but I thought we had,
Let me ask Ms. Jackson, did we vote on any of the amendments at the last meeting?
Amendment number 1, no action taken.
Could you speak up, please?
Amendment number 1, no action taken. Amendment number 2, no action taken. Those are the only two that you voted. Well, you didn't.
So we started the discussion on Amendment 3, but we didn't take an action. We didn't
Okay.
take an action on any of them.
Well, I remember, yeah, specifically not taking action on, you mentioned it, the first two. I think the
Because of,
committee was undecided on,
she wasn't here. Alderwoman.
oh, and she wasn't here, yeah.
right. And so we requested that she be here to speak to hers. I do have questions and concerns about both of these amendments. And I'm more than willing to talk about those at the committee, but I think because she was not here, we jumped right into Savage Amendment 3, and I think we got at least through amendment number 5, but I'm not sure. Maybe we have to backtrack and take them all over again.
Well, is your interest in not taking action on the O'Neill amendments again because she is not here, or are we interested in trying to move forward in spite of?
I oppose the O'Neill amendments because I don't think they're enforceable. And so I wanted to talk about changes to them. I don't know how we get to her to get to an understanding, but the way they're written, it says that there's a violation, but it doesn't define the meaning of the word violation. Does it mean that a specific citation, 3 citations were issued by police or some other entity? Because right now, if you look at her First Amendment on the second page, D, nuisance complaints, that we were told by Mr. Manessa that quite often, if the police come, that rather than issue a citation, they'll try to get the property or the people at the property to quiet down. So does that count as one of the 3 violations? And if so, where is it recorded? I don't think that goes into the police records. So I don't think this is really enforceable the way it's written, but I see that Cynthia might have some comments on this.
Ms. Reuter?
Cynthia Reuter, Office of Law Policy Analyst. These amendments, if the council doesn't do the specifics, this leaves it up to the Planning and Zoning Director to come up with the specifics on what constitutes a nuisance and what oversteps and whether they're valid or not. It would be up to the Planning and Zoning Director.
Is that in Amendment 1 or Amendment 2?
It's not stated.
It is not stated directly like that, but in absence of something stating anything more specific, it defaults to the Planning and Zoning Director's authority.
So let me take a step back if I could, Madam Chair. I'm assuming that what we're talking about is the amendments that are in blue in these first 2 amendments. So in Amendment 1 on page 2, subsection D, that is blue, and I think that is what is new. Right.
Well, the amendment is in red, right? And
No.
then someone went back and added a second correction, and that's
No.
what's in blue?
The red is the original, this is new language being inserted into, that would be inserted into the code. That's red. Blue is, represents changes to the bill. So Neal Amendment 1 is D in blue.
So the red is as introduced in the,
So the red is an amendment to the existing code,
Right.
Correct.
As introduced in ordinance
as
032.
introduced by the original sponsor.
Correct.
And then the blue is a change from the original sponsor's intent?
Yes.
Right.
Okay,
So it's on page 2, and it says any property that has been subject to 3 valid nuisance complaints. And I'm not opposed, I mean, if you have a property where you continue to have complaints, I think it needs to be addressed, but I don't think valid nuisance complaints is properly defined, and therefore, so a complaint, if the police are called, and the party is noisy and they make them be quiet, the owner of the short-term rental may be totally unaware of that. And they may not know that they have strike 1 against them because it's not recorded. If a citation is issued by the police because of the noise violation, that is recorded. But I'm not clear that even if it were recorded, that the short-term rental owner would be aware of it. I'm thinking that this is just really not, I understand the purpose of it, but I just don't see how it's enforceable. And I think it would be very easily, if we wanted to terminate or to stop their license, would be very easily appealed, saying, I never knew I had 3 complaints. I didn't even know I had 1. So I'm just not sure how. It says the owner or their property manager must have been notified of each of these complaints. I don't think there's a mechanism in place to do that. Who would do that notification? The police?
So nuisance is defined in the bill itself. It is toward the end of the bill under definitions, number 6.
page 8, line 7. And if it would be helpful, I can explain my intention with the original proposal.
Right. But this is going beyond this. So we have a definition of nuisance, but this is saying after 3 valid complaints, not even designating who is the complainer, that their license may be revoked.
Yeah. Madam Chair, may I?
please, Alderman.
So one of my intentions was to figure out a way about how to deal with when properties become a problem as far as impacting neighbors, if they have too many people staying in loud parties repeatedly, which can be a bit disruptive if it becomes a habit, like every single weekend, right? Which some of these places often become. And so what I put in there is tried to create a definition of nuisance, but if you look at line 17 on page 8, it states a nuisance would mean a property to which police or other law enforcement agencies have responded to complaints or calls for service 3 or more times within 90 days. Again, with that intention of trying to figure out, well, if the property is, and presumably the property owners would know when the complaint comes to the police department. I can't say that for certain, but the intention was to set that as, okay, this is a repeat, it's happening within a certain number of times. It's just to try to define nuisance. So I guess what the Alderwoman does is try to provide some more clarity to that by saying that clearly that the planning director shall deny or revoke the permit if a property has been subjected to 3 nuisances, valid nuisance complaints, and that the property owner has to be notified. So I guess the one question would be, if you think what I proposed is a valid definition for nuisance, the second part would be if the O'Neill Amendment 1 helps to clarify that or not.
So we have a member of the Office of Law here that I think could be asked to speak to whether this as written is actually enforceable, because this is the revocation of their license. And so I understand how you're explaining on page 8 that they have 3 complaints or calls for service within 90 days. But my questions were, is it a citation or just a call? Does P&Z keep a record of this? I asked this of John Manessa, actually. Is there a separate record kept by police? And what is the definition of valid? In other words, you could have noisy people, or you could have a cranky neighbor who, as soon as a car shows up, they're going to complain about it. So what does valid mean? And who's making these judgments? Those were my 5 questions about this amendment.
Ms. Leonard, would you join us, please? You know, I think one of the first problems is, as far as I see it, that all of the complaints are not documented. Sometimes the police don't take a report, you know, so no one knows. And it may be 3 times or more, but if there's no record of it. So should there be something that says if an officer is called to a residence, then there should be some evidence or documentation to support that, especially if we're going to use 3 as the magic number to threaten somebody's license. We should have some concrete evidence to show that they're in violation. Ms. Leonard, tell us what you know.
Ashley Leonard, Assistant City Attorney. I haven't worked on this particular one in a while, although I have been following it. I would agree with your assessment. I mean, if you're going to take this to court or potentially to court for a municipal infraction, or even if you're going to remove the license, you're going to need a document trail. And you're going to need something to attach to that citation. So yes, if you're putting in a magic number of 3, then there's going to have to be some sort of paperwork that documents each of those 3 so that it can be attached as part of the legal record.
Are you comfortable with the language that's used, nuisance, and what was your other term, Alderman? You were,
Well, I mean, I think nuisance is already defined elsewhere in the code, so I guess the question is, if we're going to call it a nuisance, we probably need to tie it in to how other nuisances are addressed. I mean, I would think that would be the easiest way. I looked at some of the other stuff. Yeah, because see, the problem with, and this is just my individual opinion, is that nuisance is already a legally sort of defined term that's used throughout for a whole robust issues. I think it would be easier, and for documentation purposes, probably easier, is if you tied this in with the other parts of the code that already dealt with nuisances, because then you would already have like a procedure in place for, like, for instance, when your grass is too high or you put your trash can out the wrong spot. Those are all also nuisances. So I feel like instead of creating a new sort of process and a new definition, my legal suggestion would be that you tie it in to our already existing nuisance process, because then they already know, like if so they get complaints about a nuisance on a neighbor, there's already people assigned to that work. There's already a procedure for how they go out there and document it, which would then, you wouldn't have to redo it for this.
Mm-hmm. So where in the code is nuisance defined other than this draft legislation?
Let me see. Oh, sorry. Put my bottle down there. Let's see. I know it's already in there because I know we already do nuisance stuff.
Because this is actually speaking back to
Well,
It's some of the red on page 8.
it's used all over the code. I mean,
It just, the problem is again, this is my personal legal preferences. The problem is when you create like a new definition for essentially the same word,
Yeah.
it just creates confusion to some extent. I mean, you could have this sort of new definition and sort of like wrap it in to other things. But
the problem is each chapter's different. Like I see a definition in chapter 1748, which is property maintenance code.
I mean, I guess you could have your own definition, but if you want a weight that makes it enforceable, I would try it and tie it in with the process you already have for nuisances versus just trying to create a whole new process.
The nuisance definition in 17 is actually pretty good, but I'd have to see if it needs to be specifically tailored for what essentially is a rental license. Because it has things in here for fire hazards, overcrowding.
Yeah, I mean, because I know we already do
Right.
all that stuff.
So back on page 8 in the body of the proposed ordinance, number 6, word
Yes.
nuisance, can we just refer to where it's defined elsewhere in the code? That's one question, but the follow-on question is, we're trying to document 3 violations and take somebody's license away, which is worth thousands of dollars a month. I mean, we're talking felony levels of expenditure here, so.
And potentially sort of it's not fully going into there, but you're getting in real property rights
Yeah.
territory.
So I get the intention. The intention is, and we did have one, there was one, was it in your ward? Or I forget, one where there was a physician who lived in Florida. It was just a party house. And every weekend during the warm month, they had a kegger there. And there were just tons of people who showed up and made lots of noise. And it was continual. And we need a mechanism to say, no, if you're not going to control your renters, you lose your license. So I fully subscribe to the sense of what we're attempting to do here. I just am worried that we're not really going to be doing it. I think it'll be too easy to evade if there's not a documentation. So if the owner happens to be litigious and said, I don't see any, show me the record where I received 3 notices of violation, I don't think there will be one. Even if the police issued a citation because of the noise, I don't know how the owner, this says that the owner of the property must have been notified, but if they're not, then it isn't really a violation. It's not counts towards the 3.
So,
So I guess a question would be, because I think we want to move forward with this legislation, can we recommend against the 2 O'Neill ordinances with the notion that we can come back later with legislative change that will make this actually relate to things that we can enforce? And then the second order question is, going back to the proposed legislation on page 8, do we need to have a whole new definition of nuisance that is specific to short-term rentals, or can we just refer to existing definitions of nuisance? And that's a question.
Yeah, well, I guess I'd want to turn to Ms. Ruther, because I think you helped a lot in putting this language together. I don't know if you recall some of your thinking behind how it was crafted.
Yes. So the answer to your first question is yes, you can not recommend favorably and just add addendums saying you would request more information or something. Regarding the definition, there's no one singular definition of nuisance in the city code. It's mentioned in several different sections, but it's tailored toward like sidewalks and street nuisances.
Each chapter.
Yeah, sewer, what's a sewer service nuisance? The one in this bill is tailored toward short-term rental noise violation nuisances.
So doesn't that present us with a legal liability of enforceability if somebody is clearly in violation and they can say, look, I didn't violate sewer, I didn't violate blocking a sidewalk, blah, blah, blah. You don't have a consistent definition of nuisance throughout the code, and therefore, you know, you can't enforce this with me.
Well, it's all over. I mean, we use nuisance in towing of vehicles in chapter 12. We use it in the IDD, illicit discharge section. We use it interference with director of public works. You know, so, and that's in chapter 11, chapter 16, 21, 17. It's all over the place. So I don't, on the one hand, I do see the point, but on the other hand, I think that's a larger question of our city code.
And I'm willing to accept that, and I'm willing to leave it in this proposed legislation as a co-sponsor, but I'm very leery of then going ahead and doing the O'Neill Amendment 1. And I guess my recommendation, my personal opinion as a member of this committee, is that we recommend against this amendment, recognizing that there is opportunity to come up with new refinements to the short-term rental legislation that can address some of the ambiguities. Attorney Leonard.
Alderman, is that a motion?
That is a motion, that the committee recommend against this amendment, but suggest that the sponsor come back with, working with the Office of Law.
Point of clarification. Is the motion just on Amendment 1, or is it both Amendment 1 and 2?
Well, Amendment 2, I think, refers to fines, so it's Amendment 1.
Okay. I will second the motion on Amendment 1.
Okay.
All right?
I think we've had discussion. All in favor of opposing Amendment 1, please say aye.
Aye.
Aye. Okay, going on to O'Neill Amendment 2.
Now, O'Neill Amendment 2 is a change to the possible revocation or denial of a short-term license. I'm not sure why this is even in, I'm assuming this is an amendment to the fee legislation 5523? No. Where's the fee? Where's the fee legislation? This seems like it's an amendment to setting the fees for violations.
I think it speaks to just simply enabling the fines. It gives us the ability to put a fine in the fees and fine schedules.
That is also how I have interpreted it.
All right.
Yeah,
Okay.
that is correct. It would require a separate resolution to set the fee.
Separate resolution in, yeah, right, like we do with all other fees. All right.
Correct.
So I don't have a problem with O'Neill Amendment 2, and I would make a motion to recommend favorably.
Second.
Okay, further discussion? Hearing none. All in favor of a favorable recommendation for the O'Neill Amendment 2, please say aye.
Aye.
Aye. Okay, so Amendment 3 is the Savage Amendment, and we just had a lot of discussion about it. What's our final say?
Well, we have, this has several different,
Madam Chair, may I give an introduction to this?
I'm sorry?
May I give an introduction to this? Amendment 3?
Yeah.
So this is, it's a compilation of, 19 different amendments. And these came about, these are in response to a public comments that we received, and one of them, many of them came from particular, I think, outside law, somebody who's experienced with law who just recommended some of these tweaks. I included the ones, I didn't include all of them, but the ones I included, which I think were most of them, were things that I kind of agreed sounded like good adjustments to strengthen the underlying intention. I don't believe anything in here is substantive per se. So I did, at the end of each description of the change, in italics, I put the description, the justification, rationale. So for example, on Amendment 1, the deletion of lines 9 through 11 is that it's just, the goal is to simplify the language. It was kind of suggested that it was redundant.
Are you referring to the amendment on page 3 of your amendment? The homeowner, condo homeowners associations?
It should be number 1 on the first page.
That seems to be the first one I'm seeing in blue.
Oh, you're looking down below. I don't know if they go in order with the blue changes. I guess there are multiple ways to do this. We could either go line by line numbered above or go through the blue in the text below.
I think the blue's easier.
The one that we have doesn't have line numbers on it,
I know, that's the problem.
but it is highlighted in blue, so it's pretty, it stands out.
Well,
So,
it looks like they do go in order, so I think that's okay. That'll work.
I'm sorry,
Yeah, access it on Legistar, it's got the numbers.
if you access it where?
On Legistar instead of through Granicus, it has the numbers.
Oh, okay. I use Granica, so I don't have Legistar, and you don't have your bar copy.
I actually have it off of Legistar, so I do have the
Oh,
line
okay,
numbers.
then I'm the one who
But
does.
once again, I'm going to complain about Granicus.
Okay, well, so my question, I guess, is for Ms. Leonard on page 3 of the amendment, the section under condominium homeowners and community and other similar associations. It sounds like we're enforcing their covenants.
And I don't think we have the power to do that.
So, Alderman, is that what your intent is?
I'm reading through it again. So what proposed to strike out, this is, the text, this is proof that any act of association with authority.
So that requirement is currently in the city code.
Right, it's what's in black and stricken, right?
Right.
So this proposed to strike that, which is very simple. It says, if an act of association with authority over the use of the property short-term rental consents to a short-term rental, does that imply that if the condominium or whatever townhouse association allows short-term rentals, those short-term rentals will fall under this change in the code?
That is already in city law. What this amendment basically does is clarify when the license can be pulled if they violate condo or association rules.
So that would put on John Manessa and his staff the onus of finding out if the short-term rental were in a condominium or townhouse, anything that has a homeowners association, and then finding out what their rules are, whether they allow or don't allow. Like my sister lives in a condominium, townhouse condominium, that does not allow short-term rentals. So how would our staff know, A, that this short-term rental is in a homeowner, something governed by homeowner rules, and then B, go find what those homeowner rules are to see whether or not they can grant them a license.
Right. So right now, the system would be the same. They go through the licensing computer system, and they answer all the questions. And city staff essentially takes them at their word at the beginning, and then if there's a complaint from the homeowners association, then they investigate.
And what does this do to change that from the current system?
It more than
Used by our
clarifies
staff.
it.
Pardon me?
It clarifies it, but also provides for the ability to actually enforce it, because it's stated in the code currently, with the changes from a couple of years back, that they have to provide proof that an active association with authority consents to the short-term rental. So it requires the proof, but the code doesn't state how, actually give explicit authority.
Not to interrupt, but I don't think the rewrite actually requires the proof anymore. You've shifted the burden with this language. So now it's saying that it doesn't require the proof to be submitted by the applicant. Now, in my reading of it is now we have to go do searching. Now, you can revoke for the same reason. I think the new 3 is good, but I think 1 and 2 shift the responsibility from the applicant to us. And I don't know if that was the intent, but that is kind of how it reads.
And I apologize, Ms. Leonard, because I called on you and then I didn't give you a chance to answer the question.
No, so I think the new 3 is good, which is accomplishing, you want to be able to revoke it. But I'm not sure you want to get rid of the onus being on the person requiring the application to have to submit it, because the new 1 and 2 don't say that. They don't say proof have to be submitted anywhere.
Right.
They just said if that exists and somehow it's found, then we can revoke it.
So your sense is that we would not strike out what is in the current code, the black with the strikeout, but add the failure to adhere to the rules of the applicable condominium shall be the basis for revocation.
I mean, you could probably even keep 2. I think the real issue is the new paragraph 1.
Well, that's what I start.
Yeah, I mean,
I see your
2 you could probably keep, and 3 you could keep, and 1 you could keep if you like the language better, but I think you still have to add something in there that says that proof has to be submitted, because otherwise you're making planning and zoning have to go search. And the other thing to keep in mind is that some homeowner associations might just be silent on the whole issue. I mean,
Well,
I
they
would-
are both silent, but also don't enforce, because in fact, there are some short-term rentals in my sister's neighborhood,
yeah.
even though they're not legal.
I mean, because like a lot of homeowner associations, a lot of the developers just use canned, bylaws, which may or may not have been updated. So I feel like then you're putting it even more onus on us to try and figure out what other things in the rules could be interpreted that way. So
Yeah.
I'd keep 2 and 3, and you can use part of 1 if you want, but I would at least add a sentence that says that the applicant has to submit proof of.
So I'm
Compliance.
hearing that if we kept the strikeout that's currently in black, and we eliminate small 1, and we would keep small 2 and small 3 under the strikeout, which would be small 1.
Yeah.
Well,
And
or
I'm
add the
hesitating because you
sentence.
really shouldn't have a 1 without a 2, but that's a whole nother issue.
Yeah, I don't know how to do a number, but I would keep the currently struck out language. I put that in, and then I'd use the new 2 and 3 to do the clarification.
I'm good with that.
Could
I'm
I
good with that, too.
Could I request the committee that we simply rewrite 1 so that we have a sentence instead of a clause.
Yeah, so add 2 sentences.
Wait, where are we adding sentences?
So-
Clear.
Number 1, C1.
So, wait a minute, are we keeping the strikeout or not keeping the strikeout?
Well, we would turn the strikeout into a sentence.
Okay,
Yep, yeah, keep the strikeout.
We're keeping the
Or,
strikeout.
well, undo the
We're
strikeout.
eliminating 1.
Yeah.
And we're keeping small 2 and small 3.
Yeah,
However that needs to be numbered or worded.
And I think her request is just as written, the original language is not actually a full sentence.
Right,
It's just
yeah.
a clause, so
Madam
fill that
Secretary,
out so that it's actually.
Ms. Buckland, could you be on the mic, please?
could we please get IT to get us more mics? I cannot believe that we can't have 5 or 6 or 7 mics on that table.
Okay, so I'm hearing a motion that we're going to,
The motion from a Rules Committee amendment to these would be to unstrike the language under C, but turn it into a complete sentence, and keep either as sentences or subsections II and III.
yeah.
is there a second?
Second.
Are you having
Okay,
fun?
further discussion? Hearing none, all in favor of the amendment? Please, I don't need to restate it. Caitlin, did you get it?
Yep.
Ms. Jackson, I'm sorry. All in favor, please say aye.
Aye.
Aye, okay. All right, the next amendment, Alderman Savage, is
Oh,
on the next page.
Yeah, so, and we did miss one, I want to clarify, on the first, third page of the amendment. You see line 1 that is stricken, and that corresponds with my number 1 on the amendment description, but that, I think, should be a strikeout in blue, because it's a strikeout of
I'm
what's
confused, which one,
So
where?
we're up here at the top of the
top
page.
page
Right,
3.
the red strikeout,
1 is stricken, and then 2 and 3
So
are
the
renumbered.
red was proposed language in the ordinance, but the amendment would strike it. So that's why I think it should be blue.
so we're striking
And
what would be 1 at the top of page 2?
yeah, and the rationale is that the point is to simply require a rental license before renting. So where they advertise is not really relevant for this particular clause.
Okay, and this has to do with advertising, the rental,
No?
the one that we're striking.
Yeah.
Oh,
So you can't advertise until you have a license. Is that correct? And that's what you're taking out?
I'm trying to remember why. This has been going on for too long. I can't remember all the decision points. I know originally this was put in, the language was put in because we want to make sure that have some kind of provision where they, before they post it publicly on any of these platforms, that they have to have a license, right?
So there was no language about them needing to have an application before advertising? I thought that was part of the original.
Right, so the reasoning
Language.
behind the strikeout there, according to the italics, the point is to simply require a rental license before renting, so where and how they advertise is irrelevant.
Where and how the advertisers
so-
do what?
It, basically, they already must have a rental license, so it doesn't matter if they're advertising on the platforms, because they can't advertise until they have a rental license. according to the platform.
Right.
I still don't understand.
According to the platforms, they're not going to allow them
So the
to
platform
advertise
will
unless-
patrol
yeah.
that. Okay.
And the
Well,
platforms,
no, this is just saying basically they're not going to be getting, they can't rent it, period, no matter where they advertise. They can't rent it, period, unless they have a valid license. So that's why it doesn't really matter. We don't have to narrow it to say particular platform or not, right? It's because they have to get a license to begin with, right? Is that?
I think I'm a little confused because I looked at the map and it showed all of the rentals that don't have licenses.
yeah,
So,
that are advertising on platforms.
that are advertising on platforms.
Yeah.
So,
I
and
may have that
by
wrong.
the looks of the map, there are more that are advertising without a license than advertising with a license.
Yeah, but that's, I guess the point is that's already prohibited because they can't, if it's advertised or not, they need a license, period.
I mean, I'm not opposed to needing them, requiring a license. I'm just
I mean, I don't
stating the fact
I don't
that,
feel strongly about this amendment.
My feeling is it doesn't hurt to have this because there are other forms of advertisement besides platforms.
Yeah,
So they can just strictly advertise in the Capitol. Or they could be putting it on various other bulletin boards. Maybe it goes into, what are the, Kindle or whatever, or eBay. So
Yeah.
those are not the recognized platforms.
so are you suggesting that we unstrike the strikeout?
That's my inclination, is to leave it in. I don't think it's
fine.
hurting anything.
yeah.
So where does that leave us? The committee recommends that we oppose, which amendment
So
is
you'd be a
this?
no on,
That's all part of Amendment 1.
yeah, but you'd be a no on sub-amendment 1. You made changes to sub-amendment 2.
So the Savage Amendment 1 speaks to all that's in blue plus the red strikeouts,
Right,
right?
yeah.
So we need to highlight page 3, I guess it is, and lines 1, 2, and 3, that we want to unstrike.
Unstrike 1 and keep the numeration 2 and 3.
No, we're talking back up here.
Yeah,
Oh, okay. Renumbering. Is that what you're saying?
yeah, the renumbering is in blue, so
Right.
if we unstrike 1, that means we keep it, we keep
2 and 3,
2 and 3.
the original 2 and 3. Is that a motion?
So move.
Can I get a motion? Can I get a second from the rear of the room? Thank you. All in favor, please say aye.
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 Now, does this become a Rules Committee Amendment 2?
It would be, yeah, substitution amendment, I would, assuming I agree with everything, but I think I'll agree with everything.
I'm fine with that, or they're still the Savage Amendment.
Well, I know, but we're amending the Savage amendments.
Well, he
Yeah.
can amend his own amendment too. I mean, we could let you weigh in.
Well, I'll probably just withdraw mine and introduce.
Okay, well,
support
these are
yours.
the Rules Committee amendments then.
Yeah.
So we have 2 so far. Okay, so let's go on to page 4, I think it is, and I have to pull up the one that you guys use.
Oh, yeah.
Under license restrictions,
Right?
Yeah,
I see
So this is,
1.
well, the rationale for this one is to provide further clarity that a short-term rental license and property manager, sorry, short-term rental licensee and the property manager have to be local, which was something that we put in the code with your legislation.
That is in the code already.
It is, not worded like this. It was reworded to be specifically, because we adjusted the definitions of licensee and property manager and owner.
Oh, come on.
Because there was a lot, they were using, the language was contradictory, and they were using that to get around some of our code requirements. And so this just, with all the other adjustments, this just provides that clarity that the licensee has to be a resident of the city.
So I'm looking for the original language under license restrictions. Does that not fall under that category?
Is this one of those things where we struck it and moved it? So it's one of those things, goes back, way back to our question, how do we crosswalk? So I felt that this was something where we'd, for clarity's sake and organization's sake, we had struck it in the current legislation, in this proposed changes, that struck but then repeated here in this section under license restrictions.
Well, wouldn't we see it, though, with it strike through? Or because it's in another section, we're not going to see it?
That's my sense.
Ms. Reuter?
There were so many changes to the original bill that it would be very confusing to try to figure out what the changes are. So we struck the entire thing and then rewrote it. All the things they're doing with the city, all the requirements for city, for the owner are all grouped under owner. Everything for the property manager is grouped under the property manager, whereas before there were things that had been added at different times, and so those different type of jobs were scattered throughout.
So could you tell me where in the original legislation we struck out all of this language?
Yeah, you have to go back.
Well, I guess
This,
I'm not quite sure what you're getting at with that. 'Cause I think a good question might be, do you think this language in blue supports your original intention with what's in the code now, what we passed a couple years back? And that original requirement was local ownership, right? You have to be a local resident to have a short-term rental, and if you're not, then you have to have a local property manager who's available, right?
And that's why I'm trying to find it in the original legislation. To make sure that it speaks to the intent that we were trying to get at when we created this legislation originally.
the strikeouts start on page 2 in the first reader.
Sheila, I have it. Do you want me to read it?
I'm sorry,
I have the section you're looking for. Do you want me to read it?
could you help us?
Sure. It's if you go back to the first reader, it's, well, I just scanned it. There is a section on property manager. It's under page 6, line 9. And it says, for licensees using a property manager, the property manager shall reside in the city and provide proof of city residency, or have a primary office located in the city of Annapolis at a commercial address and provide proof of occupancy, and be available and have a designee available by telephone at all times in the event of a public health or safety emergency involving the licensed property, and be identified on any application required by section 1744-040 of this title regarding rental operators' license applications and renewals.
That's right, that's it. So what does this new language change?
Well, it specifically references what Ms. Leonard just read. And so it says a licensee or property manager must meet those standards that she just read. It just clarifies that that's part of the license restrictions.
Okay, so you're good with just restating what was already stated in the original language?
So what we're trying to do with this is make sure all the license requirements are in one section, so it's clear when staff's reading through. So this just reiterates that it's already stated, like Ms. Leonard had in there. I'm not proposing to change that with amendments. But just
Okay, what, Alderman?
So I have a problem with 2, and it's the problem.
That's a different one.
Pardon?
That's a different amendment, sub-amendment.
Oh, the licensee shall be allowed one short-term license,
Yes.
which shall apply to only one dwelling unit?
That is.
That was original language,
Yeah.
except,
So that's to prevent a loophole where someone owning multiple buildings on a property could rent all of them as short-term rentals with one license.
All right, so that's my question. So right now, Mr. Manessa, when he issues a license, will issue it to the whole building, even if it has multiple units in it. And that's particularly the case of the Crabtree family, where they lived in one unit and they had 3 other units that they wanted to be all short-term rentals because it's in only one dwelling unit. And so my question is that if you had a 4-unit building, how many of those units can be short-term rentals? And my sense of the intent of the code was only 1. But the way it's being processed by permits and inspections is all of those could be short-term rentals because they're in one dwelling.
Yeah, well, it depends on how it depends on how plan zone is defining it. Are they defining a dwelling unit as a building, one building?
That's how
Or are they defining it as each sub-room? Because what I was trying to prevent here is having multiple buildings. You could have multiple buildings on a property and have, if they are all considered,
But we know that the Crabtrees had a building with 4 units in it.
yeah.
They dwelled in one, and the other 3 were short-term rentals, which implies to me that you can have more than one short-term rental. And so my question is, does this speak to that situation? Not multiple buildings. I think we're pretty clear. You can't have multiple buildings, one owner, and have multiple short-term rentals in different buildings.
Okay, I understand what you're
But the
saying.
question is, if you have one building that has multiple units in it, and the way that they're licensed now by planning and zoning is, you get a license for short-term rental for that building. And in fact, the Crabtrees made a passionate appeal that the way the code was written, only one of their 4 units could be a short-term rental, which I think was the original intent, and they wanted the other 3 to be short-term rentals. Now, fortunately for the Crabtrees, I think they've sold that building and moved on, but it raises the issue when you have a multiple unit building, it's a dwelling unit building, how many of those multiple units can be short-term rental?
I am looking, do we have a definition for dwelling?
Yeah.
I'm sure we do, but I'm
Dwelling
not
in the
seeing it
code, for sure.
in this section.
There is a definition in Title 17. It says dwelling unit means a room or group of rooms located within a dwelling and forming a single habitable unit with facilities which are used or intended to be used for living.
Okay, there's also one in chapter 21. There's dwelling, single-family detached. Oh my gosh. Dwelling unit means any habitable room or a group of adjoining habitable rooms located within a dwelling and forming a single unit with facilities that are used or intended to be used for living, sleeping, cooking, eating. So that says a unit could be one room or a group of rooms.
Right, and we
Right.
outlawed tenement houses where there was a building where bedrooms were being rented, were used quite frequently by our delegates to live in, but also for other more nefarious purposes. And of course, we have passed the accessory dwelling unit legislation, which means you can have two dwellings on the same property. And when we passed that, we allowed that accessory dwelling unit to be a short-term rental. So I don't know that the way that P&Z processes this is they issue the license to the structure without regard to how many different dwelling units are in that structure. And I don't think this addresses that situation, and
Right.
I think it's an open question. If we have a 4-unit structure, can all of them be short-term rentals? No, but so somebody has to be a resident there, although they could be a long-term rental and then 3 short-term rentals. So how are we addressing this particular situation?
So this language doesn't change the way it's currently applied, for better or worse. What it does is simply clarify that it references dwelling unit. So in this case, it clarifies that, well, you can have, this is for a building, one building. Because the current code doesn't, I think that's what it requires, but it doesn't come out and state it. So, that,
What if we changed it to dwelling structure?
well, I don't know if we have that defined elsewhere in the code.
All right, so in the solid waste
In the what?
chapter of the code,
I'm sorry, I missed what you said.
Solid.
in the solid waste chapter of the code,
Oh,
it has, I think it has what you're getting at. It says, for the purposes of this section, every apartment and condominium unit shall be considered a separate dwelling unit, even though one building may contain more than one unit. We could use that sort of language.
I know some people associate short-term rentals with waste, but, well, I mean, is that an addition to the blue language?
Well, if I could suggest, maybe no action on that particular, not include that particular sub-amendment, because it sounds like we need more discussion on that.
Yeah, but then that means we've struck it elsewhere in the code.
Well, it would mean that it would default to this ambiguous definition of dwelling unit, which we don't have. Oh, we do have it in chapter 17, which is what this under. Dwelling unit means a room or a group of rooms. So it would default to the definition in chapter 17, which is where this is located. So ultimately, I don't think this amendment is needed, the language.
Well, but it has to be in here because it's replacing language that was struck elsewhere that Ms. Leonard read to us earlier, right?
No. What she read earlier was just referencing that the requirements for a licensee or property manager. This just has to do with how many licenses, what the licenses apply to. Do they apply to, how many can a person have, essentially? But
So going back to your 1 through 19 amendments, which one, if we did not take this new blue, which amendment is it that we're striking and we're not accepting?
It would be number 4, number 4. So if this is not accepted, which is, either way, it's the same thing, but again, I don't think it's needed because,
So the action by this committee would be to recommend against Savage Amendment number 4? And that would make this blue, all of this blue go away?
let me just make sure. We need to find the original language that restricts. Okay, so in the original legislation, it says the licensee shall be allowed one short-term license. And then number 2, for the purpose of determining that only one rental operator's license is issued per licensee. That's not. It's all admittedly very confusing.
So my laptop has died, so I can't find the original legislation. I'm worried that we might be throwing the baby out with the bathwater.
I don't think it hurts to have the clarity. But it does bring up the question you brought up as far as, I know you want to restrict the number of rooms essentially that can be used as short-term rental, right?
No,
I don't know what your original intention was when you passed the legislation a couple years back.
Right.
Was the intention to have?
Just,
Okay.
I can't get back to wherever Madeline had me. I'm worried that if we don't accept this, because 1 says a licensee must be a resident of the city or a property manager that meets the standards in 1744-090. If we don't accept that, are we dropping that definition of who a licensee must be? Thank you.
If you drop the blue language in number 2?
No, blue language number 1. Are you recommending that we drop
No.
this whole amendment?
No, number 1 you already voted to
Oh,
support.
God, this is so impossible to follow.
Should we call on Ms. Leonard to help us out here? This is.
Well, I mean, in theory, because they're all lumped together as Amendment 3, if you only want pieces of Amendment 3, it might be easier for Alderman Savage to withdraw and sort of resubmit a new amendment versus trying to decide which parts of Amendment 3 go forward or not, but that Ms. Reuter might have better thought on that. And then you also, of course, have your Amendment 4, which also provides alternative language to the same thing that you're talking about right now, which is the same sentence about dwelling, how many licenses per dwelling units. So, yeah, so what I would say is if this is too confusing, maybe have Alderman Savage resubmit the, I don't know, a new package amendment. I don't know how to, procedurally, I don't know the best way to parcel out different parts of the same of a very long amendment.
Well, I think what we're gonna have to do is the committee has their own changes they'd like to make. So what I'm thinking is, we'll take this, my amendment 3, and just incorporate all their changes into it, and that would then become the committee. So it would be redrafted, but with all their changes. So in this
Yeah.
case, whatever I think they've decided to keep changes in number 1. Right now, the changes in number 2 are up for discussion, as far as if you want that language clarifying that a licensee shall be allowed one license, which shall apply to only one dwelling unit. So that's the question, I guess, before the committee right now.
And I don't know if you want to discuss Amendment 4 or not, because Amendment 4 offers an alternative to that language.
Yeah,
So
I kind of want to wait on that.
Yeah,
think.
I'm just merely,
Yeah,
if you want to
before-
wait, I just
yeah.
don't know if you want to do
This is the
that.
guts of the legislation. I mean, this
Yeah.
is really what we're trying to achieve is one per customer. And you can't be a whole bunch of LLCs. So I think this is critical to making sure that we're making an improvement on the current form of the legislation.
I mean, adding dwelling unit is smaller. So it's, even though it could be multiple rooms, they're all rooms that are combined and considered as one sort of livable area. So by adding that, you are shrinking it from the dwelling to something smaller, because a dwelling unit is a smaller subset of a whole dwelling.
I will check your, because the definition in chapter 17 is that dwelling unit means, it can mean a room, but it also says or a group of rooms.
Right, but they're all sharing usually like a kitchen, bathroom together. Versus you could have a dwelling that is like a multi-family unit, which would have multiple kitchens, multiple bathrooms.
Right.
Generally, dwelling units, however defined, are all sharing some of the same core things, like a bathroom and a kitchen. You could have multiple bedrooms, but they're sharing some core stuff, whereas a dwelling could have multiple units in it that each have their own sort of like, if you kind of think of it as sort of like dorm rooms, they each have their own little pockets.
How is that not a rooming house? And I thought rooming houses were outlawed in the code.
No, because you have like, for instance, because you have like multifamily dwellings is a defined term in our code.
Yeah.
But multifamily dwelling units each have their own independent kitchens, bathrooms.
Right, and each one of
bedrooms.
those is a dwelling unit
Right.
within the multifamily dwelling.
So this thing where you can have multiple rooms that are sharing common facilities, bathrooms, kitchens, so forth, is a rooming house.
I mean,
If you're renting out just the bedroom separately,
Well, but no, this definition doesn't necessarily imply renting. It could be owned. So you could have a multifamily dwelling that isn't being rented, it's just owned and used by multiple families.
I think the difficulty with this definition exists in the current code too, right? Because if you look at how this is currently written in our code, it says the licensee may not hold more than one short-term rental operator's license. It's kind of silent as far as, I think, as far as if that applies to a dwelling unit, because I don't exactly know what the limitation is on in the current code. I mean, it says no short-term rental operating license shall be issued or renewed without inspection of all rooms and dwelling units. I don't see a limitation.
So we are not going to change the terminology. So what is it that we can live with here?
Well, we could just not make any changes to it, which would default to the current language, and for better or worse.
yeah, but see, we're losing something because if you look at the current license restrictions, a licensee shall be allowed one short-term rental. That's not in here. And then, in here it says, a licensee must be a resident of the city, or have a property manager. It feels to me like we're losing.
It's in there. Because if you look at C2 in the amendment, it says in black, a licensee shall be allowed one short-term license. And the original code says,
The original code did it by premises, which included dwellings, dwelling units, bed and breakfast. So the original code, which I helped write many moons ago, did not narrow it down to a dwelling unit. It applied to a bigger premises.
Right, like the 4-unit building.
Correct.
so that's,
And so the license went to the premises, which was meaning dwellings, dwelling units, bed and breakfast homes, hotels, motels, and inns that are required to be licensed. So
okay.
So it was a license for the whole premise, and the premise could be a big variety of different types of buildings, which could include dwelling units, but also could include much bigger things. So that's, right now, when Alderman Arnett is saying that they license for the whole thing, that's what they're doing. It was one license per premises, which was could be big or small, depending on how the applicant submitted it. So if you want to change that, then you would need to change that definition of premises. And I haven't read that to be something smaller.
Okay, so maybe then we should not change it at all. Because
Well,
then
right
it would
now-
go to what you originally wrote.
Yeah, I mean, 'cause so if you're gonna add this line in here, you'd probably also have to
Yeah.
make sure that those other parts are
It kind of
also all shifted.
It all kind of opens up a can of worms that,
Yeah, because what's in there right now under license restrictions is a licensee shall be allowed one short-term license. It doesn't, I don't know where this language about, currently where this language about be a resident or have a property manager goes to if we don't accept this amendment.
Well, Alderman Savage had said that he would withdraw his, and your standing committee would essentially submit a new package of amendments
Yeah.
for what you discussed today. If Ms. Reuter is okay with that. I would defer to her since she's the one who
Yeah.
has to keep all this on the rails.
I'm good with that as sponsor.
Well, okay, wait a minute.
So that would mean, Madam Chair, if the committee would be a no on sub-amendment 4, which is changing that number 2.
But that's the guts of the whole legislation.
No, it would default it to the code as currently written, including what Ms. Leonard just stated about premises. Because she's saying if we change it as I was originally proposing in the amendment, we have to deal with all these other definitions of premises, and I just think it gets beyond the intention of this legislation. I mean, if you want to adjust that, I'm happy to work with you, Alderman, maybe we can make that a new amendment, but I don't want to necessarily overcomplicate things more than
Yeah, well,
we need to.
it's quite complicated enough.
I know,
Thank you.
that's why,
And I thought I understood all of this.
well, so did I.
I'm afraid that, again, we're throwing the baby out with the bathwater.
Yeah,
The does show up here later that a licensee, where is it? The new 2, a licensee shall be allowed one short-term license which shall apply to only one dwelling unit. And that, I think that's what we were trying to do. And I like that. The licensee must be a resident of the city or be a property. That's already in the code, so that's just restated here. And that's why I'm afraid if we drop this amendment and it's stricken someplace else, that we lose that. And I don't want to lose that.
well, the sub-amendment 4 only deals with that line 2. So you can say no to that sub-amendment 4, but still have,
So
1 and 3.
that's Amendment 3, right? The licensee Must be a resident. Okay. So that would stay. So 4 is saying licensee shall be allowed only one dwelling unit. That's 4. And again, that's what we were trying to do, is say you can only have one. You couldn't be a owner and then be an LLC and be something else.
My only suggestion from a legal perspective is you can add in that blue language that it shall only apply to one dwelling unit, but there are probably other spots in this section, including the definition of premises, that would all need to be adjusted if you really want those extra words to like not conflict with one another.
Okay, how about this? How about if the committee agrees, we could just keep that language in there. I could make a request separately, because I'm trying to keep the legislation moving. We've had a long time. I can request legal review to see if we need to make additional changes.
It would just be a cleanup to make sure that you don't have anything else, because the original legislation was not intended to narrow to a dwelling unit. So you'd have to do it like once over just to make sure there isn't anything in there that would conflict, because then you're got loopholes again.
Yeah, and I could make that like a separate amendment.
So I think I like the direction it's going. Personally, I'm only one of the 3 committee members, but it does.
Alderman, I'm going to ask for a motion.
Well, I'm thinking that the motion is actually coming from the primary sponsor, which is that we postpone.
He can't make a motion.
Postpone, I know. So I move we postpone continuing to take up this until the next Rules Committee so that we can get this cleaned up.
Well, that's not what I'm suggesting.
All right.
How about, because what I was suggesting is we kind of include the language like the city law office said. We can include it, but I'll make a separate request to see if I need to include another amendment to clean things up. But I think there's a lot more we can go through here to see. I don't know if that's necessarily going to hang up.
I don't want to lose Amendment 4. To me,
yeah, that's fine.
Your Amendment 4
we can keep
is,
that in there, but I'm going to see if we need to do further clarification.
So are you comfortable with making a motion on Amendment 4?
Yes, I move I think on this blue we would be moving favorably on Amendment 3 and 4.
That's sub-amendment 3 and 4.
Okay.
And 5.
Well,
So that would be accepting all 3 of those amendments, which show up here on this page in blue with the renumber.
Well, right now, let's deal with Amendment 4.
All right?
Amendment 4.
Amendment 4, which is on the first page of Savage Amendment.
Sub-amendment 4.
Yeah. The licensee shall be allowed one short-term license, which shall apply to only a residential home containing 1 to 4 dwelling units. And a license shall be allowed one short-term license, which shall apply to only a residential home containing 1 to 4 dwelling units. Same thing.
Well, that's not Amendment 4.
That's Amendment 4 on mine.
Mine says on page 5, line 15, after license shall be allowed, which shall apply to only 1 dwelling.
So I think the point of confusion that I was trying to clarify for everybody's clarification, you are wanting a favorable recommendation on Savage Amendment 3, subsection 3, subsection 4, and subsection 5. Is
Correct.
that a correct and clear
That was
explanation?
my intent, yes.
Okay.
So we're still talking about Amendment 3 then?
Yes, Madam Chair. But subsections 3, 4, and 5 of Amendment 3. And the rest you are wanting to strike, Alderman Arnett, was that your motion, or was your motion purely just on 3, 4, and 5?
Quite honestly, at this point, I do not know. I do not know. I'm on the front page of the Savage Amendments. I think 3, 4, and 5 are all contained in this blue language that's on whatever page this is, page 3.
Isn't that what this is?
Yeah, that's all Amendment 3. So Amendment 3 has all, Amendment 4 is very short. It's literally 2 lines. Everything else is in Amendment 3 with Alderman Schneidermeyer's prescribed sections.
So all of these, what I thought were more editorial changes, are all part of Amendment 3. There is a separate Amendment 4.
Correct,
And a separate Amendment 5,
correct.
which are not referencing 4 and 5 in 3.
Right.
So your motion is Amendment 3. And I thought we had already given a favorable on the condominium homeowners piece of that. It's a rules amendment.
Yeah, and I'm keeping
Okay.
track, I can share with you of,
So that's the rules amendment. But now we're still in separating Amendment 3.
yeah.
And
Right.
Alderman Arnett.
And there are more beyond that.
Yeah, so, so number 5 is the line 3, which deals with signage. I can't remember exactly where this came from, but the language would basically say that they can't post signage on a property indicating that it's a short-term rental advertising it unless it's approved by the director.
So that's also part of Amendment 3. So you want that separated out
Yeah,
as
well,
a separate amendment
It's 3
also.
subsection 5. But that, yes.
I think part of the confusion is that we are breaking this one amendment up. Your, Alderman Savage, your amendment,
Well, it's,
because it has so many pieces to it.
it does, well, it's, because it's actually 19 amendments in one, and that's why it's confusing. On the first page, I haven't broke them out with justification. But I think that's leading to some confusion. So I see I think what we could have done is just made it one giant amendment, no subsections, I suppose.
So,
Yeah,
so the Rules Committee amendments, are we on 3? No, we're on the first Rules Committee amendment, or
Yeah.
the second?
first one.
We're on the Savage Amendment 3. Okay, which could be the Rules Amendment 2.
Savage Amendment 3 only applies to the first blue section of blue, which is number 1. Amendment 4, Savage Amendment, applies to the second
Which
new
we haven't
number 2.
gotten to that.
No, Amendment 3 is like 10 pages long.
There are others in 3.
Well, that's not here.
You're on the first page.
I know, I'm looking-
Go beyond that, go beyond that, go beyond that, go beyond that, go beyond that,
Yeah, no.
go beyond
here.
that, go beyond
Go beyond?
Yeah, so there are a lot of other changes. They're most editorial after this. It adds a couple of
Where's that?
words. It takes a couple, and that's all listed here, the 1 through 18.
But that's- Is this Amendment 3?
No,
No.
all these are Amendment 3. They're just broken out.
Well, okay, Amendment 3, number 3.
Yeah.
And Amendment 3, number 4, and Amendment 3, number 5 are all showing up here.
No, there's all these pages. All these pages are all those. It's kind of one amendment. This is just in an effort to explain each change. Each change in here, each blue, because it's hard to explain. I don't know how else. I mean, you could just ignore all these numbers and we could just go through the text, and I'll make a note of which one it corresponds
Well,
to.
and that's what we've been doing, really. We've been going through
The blue,
the blue
right,
So if you
on
wanna
the,
keep doing that, we need
not
to
on
pick
the
up right
list.
here.
okay. So.
That's fine, let's pick up on number 3 here.
Right,
the
which
signage.
which is the adding which shall
C
be
under
only one
license
dwelling.
restrictions, number 3.
Yeah,
Right, okay. All right. So have we already voted on the licensee must be a resident of the city or be a property owner?
Isn't that already
Yes,
in the
yes.
language?
Okay.
yeah,
And
you already
then-
voted on that.
And then the licensee shall be allowed only one short-term rental, which will apply to only one dwelling unit. Are we approving that?
Is that part of our second amendment? You know, is all of this under C, license restrictions? Part
Yeah, all
of,
of this is under license restrictions.
I would say yes, and I believe Alderman Savage, the recommendation was you approve it, and then he was gonna work separately with the Office of Law to just do a double check to make
Yeah.
sure there aren't any issues that result from that.
okay, so the Rules Committee amendment will be license restrictions, letter C. One, which speaks to property manager. 2, 1 dwelling unit. And 3, signage.
Well, it's
Well,
gonna,
and
it's
for-
gonna be, the way I envision it is your amendment would be everything in this document plus whatever changes you want to make to this. All the blue in here is what I want to get from you, is whether or not you agree with the blue that's in here. Not
Well,
just,
that's what I just went through, what was in
not just the
blue.
1 through 3, because there are a lot of other pages of
Yeah.
blue changes.
So everything that is showing here under C license restrictions, all the way through to new number 9, and it would be, it would end at section D, property manager requirements.
That's correct, and that
Yeah.
would be the rules amendment.
The rule,
Well,
was it an
well,
amendment or
I don't know
just
why you're
approved?
stopping at D, because there are a lot more changes in
Okay,
here.
Well,
I
we're
was just
just
trying
trying
to
to-
break it into
yeah.
doable pieces.
right.
Okay.
So
Okay, so we can keep going. We can keep
Okay.
going. So we have 3 pieces already. So the next piece would come on page, I don't know whether it's page 5, G, enforcement and penalties, cause for denial, suspension, and revocation. Small 2, small 3, any material adverse effect
Yeah,
on
see,
public
I
health.
don't want, because I have a problem with what material means. But, so, I mean, I would like to make a motion that we approve all of the recommended blue changes under subsection C, license restrictions.
Okay, that was my first point.
Yes, right.
Can I get a second?
Damn it. I will second the
Okay.
motion.
All in favor, please say aye.
Aye.
Aye. Okay.
Right.
So now the next piece is,
Enforcement and penalties.
and we're only looking now at not new language in the amendment. We're looking at new language in blue.
Yeah, everything that's in blue.
Correct.
Okay, so we're assuming that we're already accepting what's in red.
Yeah.
Correct.
Okay,
So the question under
because I
This-
have a problem, but you go ahead.
this section is any material adverse. I have no idea what material means here.
Alderman, I'm going to ask you to hold on.
Okay.
Because I have something from the previous page, and I
All right.
want us to stay in order.
Okay,
I have an issue with D under property manager requirements. I vividly recall any number of property managers coming before us to testify over the years. They don't have offices. Their offices are their homes, pretty much. And so 2 says that they have to have a primary office located in Annapolis at a commercial address and proof of occupancy.
so, My sense is that if they're a registered business, even if they're operating out of their home, that is their commercial address.
As
It
long
doesn't
as
mean-
that's acceptable in the office of law.
I don't know for sure on how that works. I mean, I do know that when you register with like the State Department of Assets, Assessments and Taxation, that you can use a personal residence, but I don't know if they call it a commercial. I don't know if that's I know you can set up in your home, but I don't know if they use the word commercial or if it's just, I think they use principal.
And it's an or, so you
Yeah.
can reside in the city or.
Yeah, so I mean, if they're at their home, they could probably hit 1, which is they reside in the city and provide proof of city
Okay, all right, that
residency.
makes sense. So what if we
So-
just strike at a commercial address?
Or you could be, I think they use principal office as well as what SStat uses. But regardless, you could hit D1, even if you can't hit D2 with your primary office. If they're using their home and they live in the city, then they're under D1.
Yeah, so
Well, that's right, this does or.
Yeah, it's an or.
well, the issue we had was somebody was using a short-term, they were listing, they didn't live, the owners did not live in the city, and they were listing a local property agent, but they were listing, and the property agent did not live in the city, but they were listing another residential address owned by the owners, another short-term rental, as the business location. And so essentially they were trying to play games with our ownership to get around our local ownership, because that's what I'm trying to strengthen is the local ownership or local property management, right? Because in this instance, you can't run a business in a short-term rental because you can only have a license for 90 days. But they were still trying to use that to get around our ownership regulations. So that's my goal with all this, but I'm open to tweaking the language.
I'm not comfortable with the commercial address. And I think Ashley Ms. Leonard has given us an option for a principal.
If I can get the SStat website to work, I can find you what it says, but currently, let's see.
It says primary office, do we just say,
Yeah, I think they use principal office or primary office, something like that is the terminology.
Have a primary office located in the city of Annapolis at it says commercial address.
so if we strike at a commercial, have a primary office or principal office located in the city of Annapolis and provide proof of occupancy?
Yeah, so SStat uses principal office.
Right.
I mean, if you really want to be specific and you want to make sure you could say their principal office registered with SStat is.
Yeah,
So Rules Committee Amendment number 3 would be
I'd be fine with that, I
under
think.
Property
Yeah.
Manager Requirements, Section 2. We would strike primary and substitute principal. We would drop the clause at a commercial address and just say City of Annapolis and then go on and provide proof of occupancy. I'll make
Correct.
that motion.
Second.
Okay. Been moved and seconded. All in favor?
Aye.
Aye.
Did Ms.
Okay.
Ruther, did you capture that? Okay.
All right, now we're on to the next page. Alderman Arnett, you were questioning the
under-
meaning of material.
Correct. Clause for the,
Ashley, is this what it's like being an attorney? People question words like material.
Well, material is a common law defined term. So like if you were to look at cases, material does have a legal definition. It sets a standard, essentially. So I don't personally have from a legal perspective, I don't have a problem with inserting material because what it's saying is it's taking it from like any sort of little effect. And it's saying that it has to have like a legally noticeable effect, essentially. So it's creating sort of a baseline.
Could a synonym be meaningful?
Yeah, or substantive is another one they use a lot of the times. It's all it's saying instead of saying it's like a minor or small effect, that it has to reach sort of a baseline of effect. And I think it's well enough fleshed out in cases that if you had to go to court on it, it wouldn't be.
Okay, so I'm fine.
Yeah, I don't.
You fine with material?
Yes.
Okay, what about as determined by the chief of police?
Yeah, I mean, does the chief know that we're giving him this assignment? And, I mean, I think this,
You could add or designee. But I mean, he already has the power to designate, so you don't really need to do that. I mean,
but who else? Because this isn't just in police, this is also planning and zoning, right? Permits and enforcement? Doesn't the enforcement staff also have powers here?
for some of that stuff, I would say, yes, there is probably, but I mean,
So should we say here, as determined by the city manager or their designee, or his or her designee?
yeah, you could do
that'd
that.
be good, yeah.
I'm not sure why you put the city manager in there, though.
Because
Because the city manager.
he or she is the,
Oversees all the departments.
oversees all, so
Yeah.
he or she would just kick it the right direction.
So if it's a public safety hazard in public works or wherever, it could all apply.
Okay.
Yeah.
Right.
Yeah.
So I would make a motion from the Rules Committee to,
We have one more, if you don't mind.
oh, okay.
The next one is the word "or." Fraud, misrepresentation, or false statement in the application or support of. Instead of "and," it's "or."
Yeah, well, I was speaking to this one here, under BIII, strike chief of police and add city manager or his or her designee.
Right, we have that.
Okay.
I'm trying to put all three of these together.
I
There's
think-
one more.
I think you need the or because it looks like you prior deleted a fourth one and somebody forgot, and you forgot to insert the, so I think that's purely grammatical.
Okay,
All right.
so we're keeping
Or was that
material.
strike in red? Also?
We're adding city manager
amendment.
We're keeping
and
or.
his designee, and we're keeping "or." So that's the rules amendment number 3. Is that correct? Ms. Jackson?
You guys just voted on number 3, so this would make it 4, or is this included in 3?
I can't hear you.
You guys just voted on 3.
So this is 4.
four.
So this is 4. Okay, is that a motion?
Yes.
Second.
All right, all in favor, please say aye.
Aye.
Aye. Okay, on to the next page, neighborhood. What is the meaning of neighborhood?
Mr. Rogers knows.
Alderman Savage, you want to speak to why you don't know what neighborhood means?
What's,
Or why we don't know what neighborhood means?
it's given a specific, because
Well,
it disturbs the neighborhood earlier, right?
I'm looking
So-
to see where it's used. Wait, hold on. So it's used in that nuisance section, and where as introduced, it says, oh, an act that significantly affects other residents of the neighborhood. And so it also talks about, it also talks about if the property diminishes the value of neighboring property and is harmful to the public health, safety, welfare of neighboring residents, or obstructs the reasonable use of other property in the neighborhood. So this just tries to provide some limit to that, right? As far as what an actual neighborhood would mean, because like in my neighborhood, well, call it neighborhood, but it's a big loop, right? And so we don't necessarily want it to be the big loop. So that's why I kind of threw the idea of, like, if you're in Eastport, it'd be one block, but if you don't have traditional blocks, what's the limit? And I just kind of put the 500 feet of each other, whichever is less. If the law office thinks it's not needed, I'm fine with dropping it.
So, committee members, are you good?
I'm fine with it.
Alderman, what is your name? Shadomeyer, I'm
Jeez.
sorry.
Why are you being mean to Brooks?
I'm not being mean to Brooks, I just had a senior moment. I'm allowed.
I like the definition.
Okay.
I think it provides clarity in areas, and
You do like it or you don't like it?
I do.
You do like it? Oh, okay. All right.
Then we have
Would you
the
like to
change.
make a motion?
Well, we have the change from 90 to 180 days, which seems
Well,
like it's.
let's finish this other one first. So, or are you, okay,
Oh, I'm
I'm sorry,
trying to
you
do
want to
all the
add?
blues.
You're right, you're right. So
And
180 days?
Actually, we're so close, there's only 2 more blues to go.
Well, I'm good with those two plus. Alderman Cheddar, you good with moving with 180?
Yeah, sure.
There's another blue in there.
I'm actually, I'd liked it to be more restrictive in keeping with the nuisance, but I'll go with the majority view.
Okay, there's another blue, the word is, in new 7A2. You can barely see it, I barely see it.
Oh, yeah. Yeah, why does that get capitalized?
And is harmful to public health, safety, and welfare.
Oh, it's a new sub-I.
This is where,
It's a new sub-I.
Oh, yeah,
that's-
it begins
Yeah,
the
so that's, it just editorial.
capitalized, yeah.
The I needs, or no, wait a minute.
Yeah, that's right.
so I think
Because
it's,
everything prior to it is eliminated.
yeah, I think the strikeout there should be blue.
So it begins with is harmful to public
Yeah.
health, safety. dot,
But is
dot,
that
dot.
like I now?
No, the word is.
think
Yeah,
I saw it.
I should not be crossed out. I should still be there.
Yeah, so it
So the
should be
beginning of
I. So
is
I,
harmful.
then this becomes I.
Okay,
Yeah.
And then
I should not be eliminated.
And I was proposing to remove that language because it's hard to quantify if something diminishes the value of name and property, or, so just,
But you didn't get rid of all of it. You only got rid
oh, I
of,
still
it's
kept the
significantly
harmful to public
affects-
health,
And then is harmful to
strike the
public.
rest of it.
okay. Are you good with that, Alderman Chandler? Okay, on to the next page. Other than renumbering, going down to the new 14, definition of short-term rental.
Right, and that's adding under C in the city, which I subscribe to.
I'm
Wait,
sorry,
did you-
under C.
Yeah, on the very last page, the blue that under 11C adds in the city,
Right,
so they can have short-term rentals
You
elsewhere.
skipped one on the page before,
Oh, I see.
on 7C.
One on
Skip the
page-
one on page 4,
Go
which
back
one?
to 7C. There's a change from 90 days to 180 days.
No, we agreed to that.
Oh, you did? Oh, I'm sorry. I
Yeah.
missed that one.
Yeah,
Okay.
the 180.
I mean, I would
Yeah.
like to see it stay 90, but I don't care. We'll be lenient.
Okay, so on the next page, is not an owner of any other short-term licensed property in the city. The amendment, the change. And then adding accessory dwelling units for more than 90 consecutive days for any single tenant.
Now, that 90 days was something we had problems with the first go-around, because it was pointed out that delegates are some of the people that use this, and they need it for more than 90 days. Brooks has got his hand up.
I'm sorry, Alderman Chennemeyer?
So I'm going to go along with this amendment, because my issue is in the 90, not in the goal of what the amendment's trying to do. I do think that 90-day definition cuts out a lot of people who do month to month, which a lot of folks do in the city, because it's hard out there.
Did we change it to 93?
That would make it worse.
Wait, what's your concern?
I'm going to go along with the amendment with the definition, the new 14 on page 8, but I just very much have issues with our definition of short-term rentals being 90 days, because that makes a lot of month-to-month leases, and then makes a lot of month-to-month leases, defines them as short-term rentals, and that just creates a lot of problems for a way that a lot of people get by.
At one point, in the old days, we had 3 months rather than 90 days, which would allow the full month-to-month rental.
Forget I said anything. It's fun.
I think the enforcement of this, whether they were there for 90 days or 96 days, whatever it turns out to be, who's going to know? But if we wanted to make sure everybody was legal and it was month to month, I mean, Brooks, this is something we dallied over way back when, and somehow we had 3 months and they said make it 90 days because we like to use numbers rather than months, but
So
I take your point.
where I'm coming from, when I first came to the city, I was on a month-to-month lease in an illegal unit, so I suppose the whole point's moot, but
No, but in fact, when a 1-year lease runs out in city code, it automatically turns to month. And so it seems to me that what we're really thinking here is 3 months.
But this speaks to not more than. So you can still do a month to month.
but could I start on a month-to-month? That's my issue, and that's where
I don't think this precludes that.
Well, wouldn't that be a long-term? What's the trigger for a long-term license, rental license?
More than 90 days.
Yeah.
It's been a while since I looked at all this. Hold on.
We're talking short-term rentals, not more than 90 days. Because then
Right.
it's a long term.
Yeah, well,
The
we're
problem, I
actually,
think the bigger issue is that long-term and short-term rentals have drastically different regulations. So if some people who couldn't sort of meet the long-term rental requirements might do a month-to-month up front, but then this is gonna hook them at the 3 months where then they can't go past 3 months, and then they also can't quite qualify for like a long-term rent, because like long-term rentals requires usually like first month and last, like there's a whole other, when you qualify as a long-term rental, a whole different set of regulations click in that a renter and a landlord might not be able to agree on. And so then it puts them automatically in this short-term rental basket, I guess.
Yeah. Basically, like, just kind of a reference point from my own personal story. I came in here, it was kind of a roll of the dice moving to Annapolis. I had no real network, no opportunities, but I loved Annapolis. I wanted to take a chance, and it worked out. So I stayed longer than month to month. It eventually turned into me living here now forever. But I wasn't willing to sign anything very long term because I don't know if I'm going to have a job next week, or I don't know if I'm going to have a employment opportunity in 3 months or 90 days or however we want to define it. So it's not something I'm going to sink the whole legislation or amendment process over. It's a issue that I have in our definition that I think takes away a lot of flexibility from people who want to stay here longer, but their circumstances may prevent them from signing that fuller, longer term commitment because it's chaotic out there and it's hard out there.
Yeah, and it's two different licenses.
Yeah.
So a place where you could start with a short-term rental license doesn't necessarily also have a long-term rental license attached to it to allow you to shift from one path to the other. Yeah, I mean, so like a renter might only be able to do short-term, and then maybe, at least initially, they might, a couple months in, might be able to do a long-term, but that premises isn't licensed long-term, so then you have to go find.
Yeah.
Actually, there's at
different.
least one property that is licensed for both short-term and long-term.
I mean, I think you can get a license for both, but I think the reality is properties probably do not get a license for both.
And if you do it for both, you pay, for long-term, you pay a $100 fee for the inspection, and for short-term, you pay a $200 fee.
Yeah, so it's two different, it's like apples and oranges, and so it's hard to go back and forth.
And again, we're dealing with some really complicated things. I'm not going to derail this whole entire process over an issue that I have kind of always had with our definition of short-term rental versus long-term rental, but.
Okay, so are those, do we have the 1, 2, 3, 4, 5? Is it 5, Ms. Jackson? Okay,
So all of the blue changes that start with denial for cause.
start with neighborhood.
Enforcement penalties, subsection G, denial for cause, which include.
No. I
There's
think
some
it
before
starts
that?
with neighborhood, doesn't it? Does it begin with neighborhood
I thought it was,
and then,
It's the definition of neighborhood, so page
Right.
7.
and there are 3
line
on that
6.
page?
okay,
And
so we
then-
already approved the ones, material.
Yeah, we did those on the last
all right.
amendment.
Yes, you're right. So
Okay, so then
starts with
on the
neighborhoods.
next page in the city, and then on the definition.
Oh, my God. Does this mean I move, we
wait.
approve all of those blues?
Yes. Alderman Savage, are you good?
Yeah, I think there were just a couple of the random editorial, I don't know, we just loop them in.
Are they in blue?
No, well, you went over some of them already. The others had to do with just,
Well, let's finish this.
Right. Can I get a second?
Second.
Okay.
Okay, all in favor on the 4th Rules Committee amendment?
Is this the 5th?
No, yes,
It's the
It's the
5th,
fifth, right.
okay.
Yeah.
All in favor, please say aye. Aye.
Aye.
Okay,
Would you rather do this or go to the dentist?
I don't know, it's a hard one to pick.
I went to college with my dentist, so I might pick the dentist.
You what? I'm sorry.
I went to college with my dentist, so at least that's a friend. I would go chat with my dentist.
Okay.
Okay, so,
You said there's some others that we haven't seen? Oh, well, isn't there an amendment 4?
I was gonna say, what, did we eliminate 3 because we broke it up into our 5 amendments, right? So we're going on to the Savage Amendment 4,
Correct.
and that is the one that deals with,
Madam Chair, Ms. Jackson has.
I'm sorry,
So we need to make a motion on Savage Amendment 3. That was introduced since we had.
okay, I thought we had divided that into 5,
right, but now it's the rules committee instead of Savage.
so you're saying we still have to vote on his Amendment 3?
To remove it, I'm assuming.
To remove it, okay, so we have to vote
You can just
down.
take no action on it.
Okay.
Okay, so we take no action, are you guys comfortable with
Yes.
no action on
No, because you.
Amendment
'cause
3?
They still take action on the whole ordinance itself, and that'll.
Yeah, but we
take
haven't
care of that.
finished the amendments yet.
Yeah,
We're
right.
going to your 4th amendment now, which is
Well,
one page,
Well, I'm just.
residential home
As much
containing
as I don't
1
want
to
to
4
go back.
dwelling units.
I don't want to go back, but there were some other just more editorial changes that weren't in blue, so they didn't jump out. So I don't know.
Are they embedded in your 3?
Yeah. So for example, where we talked about, it was the police chief, but it got changed to city manager. It talked about, when that's G1, G1B, number 3, it just talks about, as determined by the city manager. So this talks about the public safety issue. Any threat to public safety as determined by the city manager, directly or indirectly associated with the property. The proposal was to take out indirectly. So just have it be directly associated with the property.
Yeah, but that's already stricken, right? So it just says directly associated?
It is, but I think the problem is it's hard to show us. You can't show the strike in a different color. So they weren't all.
Okay, tell me where that is again.
Right
I'm
here.
on G1.
Under G1B3.
Okay,
So right here.
Or
It says
indirectly.
directly or indirectly. So are you saying you want that to stay in?
No, I'm saying I want it stricken.
But that's in red, that's not in blue.
I know, it's supposed to be in blue, is my point.
Oh, the strikeout.
Yeah.
So you do want it to be stricken.
Yes, correct. He wants it stricken, but it wasn't part of the original red amendments. It's
Right.
so it
a
should be in
new,
blue
so
with
in
the
theory,
strike?
Yeah, I guess
Right.
it's a blue,
You know,
or maybe make it purple. I don't know.
okay. Can we add this to Amendment 4? Is that Amendment 4?
And well, there's one right below that too,
Okay.
where the
Is that too
blue,
confusing to do that?
Not for me.
Okay, go ahead.
Let's see what the one,
where you have the or, it says fraud, misrepresentation, false statement. So you put the or, I propose to put the or in between misrepresentation or false statement. The amendment would be to remove end inaccuracies.
okay.
And
So the amendment is to accept that strikeout.
yeah,
So
because that's
accept-
more like inaccuracies, not necessarily intentional, right? It could be a mistake, so.
Right. So there's 2 strikeouts that are in red that we're accepting as part of your overall Amendment 3.
Yeah,
So we are adding back in letter C, fraud, misrepresentation, or false statement and inaccuracies?
No,
No, you're
we're keeping.
you're leaving the strikeout. You're just
Yeah.
acknowledging it that it's
This strikeout should have shown up
Part of the
as
amendment.
blue, just like
Okay.
indirect should have shown up as blue.
Okay,
there
so,
are 3 more, bear with me.
You are
so it is
pressing your
correct
luck.
as it's written.
I'm trying to be
Where are they?
thorough here. So the third one is under the definition of nuisance. It says an act or condition knowingly created, performed.
So
That knowingly, it should be in blue.
Okay,
So knowing, the next page, knowingly should
under
be
nuisance.
struck. And then are you going to tell us that diminishes value? Should be struck?
Well, but you did that already. And then, I think did you get the others? And then right below it, knowingly, it says local, should be stricken. That should be blue. On the
Are we
same-
still
on
on-
the same line where knowingly is?
Are we still on 2AII?
7A.
7A.
Oh,
A.
7A, I'm sorry.
7A, so no, and local. Okay.
This is just, again,
So
it's
can we make
editorial.
this a Rules Amendment 6 that recognizes these strikeouts as amendments to the code?
Yeah, I was hoping we'd be able to amend the amendments, but it's probably cleaner to do them separately. So, I'm still not clear what we're doing with the diminishes the value of neighboring property.
That's
getting stricken. That should be blue as
We're
well.
striking that, right? And we're
yeah.
keeping that.
That-
So what are we adding there?
Nothing when we're going to that new II and starting off is harmful to the public.
Is harmful to public health, safety, and welfare of neighboring residents.
And then are these or obstructs reasonable, is that also a strikeout?
Yeah, that should be blue as well.
So basically what we're doing is recognizing all of the strikeouts that were in red in this area.
Okay, so, but not all of them, right? I mean, we've left,
No, just in this, just starting with nuisance and going down. Well, and do we have one? Yeah,
we
so
just did one on a previous page.
Yeah, right, so we have that inaccuracies. And
that is
or
G.
indirectly. So all of these things are under enforcement and penalties. And it starts with cause for denial, and it goes to B, I, where we're striking or indirectly, and then C, and inaccuracies.
Okay, slow up. The first one, Ms. Jackson, are you getting these? Okay, G1, C, is there one before C?
G1, B, I.
Okay, G1B,
Or indirectly is a strikeout.
and we're keeping or directly as a strikeout.
No, yes, we're making it a strikeout, yes.
It's already a strikeout
Yes,
in
I
the
know.
document.
But we're
Okay,
making it blue.
okay.
And then we go to C, and inaccuracies is a strikeout that is now blue.
Okay,
Knowingly a strikeout,
okay, so that's 7A.
7A, and local as a strikeout.
Okay,
And then under A, II, we're keeping the II, but we're striking diminishes the value of the neighborhood property. And so
And-
that begins with is harmful,
And striking the or obstructs the reasonable use.
and then striking the or obstruction, or obstructions reasonable, blah, blah, blah.
okay. Is that it?
I believe that's it.
Alderman Savage?
One more that just adds headings, which,
Is it the last one under short-term rentals?
yeah, it adds.
All that, the strike-through serving as a temporary tourist home?
It adds headings throughout the legislation, just for clarity. License types, standard rental license, bed and breakfast license, hotel, short-term rental. It just kind of clarifies this section of code while we're in there, if I understand correctly.
All right. So that's,
So we're
I
done?
think that's it.
Okay. These are Rules Amendment 6.
So move.
Second.
All in favor?
Aye.
Right. Thank you. Okay, now, can we go back to
Amendment 4.
No, I'm not
the Savage
introducing it.
Amendment 4?
Not
Oh, my
introducing.
God. You are
You
going to be
what?
punished.
I say I'm not introducing it. No, this one came, actually, I don't know, after our discussion where I'm going to land on this one, but the intention of this one came from the people who testified. What were their names?
Are we on 4? Amendment 4? or- Yeah, okay. And so would you consider that we've accepted A? So you have a choice
I
here.
think this may have already
As-
been addressed with the last amendment. Oh, except this, yeah, I think it's already addressed because in our code, a dwelling unit can contain.
So are you withdrawing Amendment 4?
Actually, let me just get with the law office. Don't worry about it, and I'll see if it's even needed. Because in light of the other changes, it may not be.
Yeah.
I have to look at, I was debating, because yeah, in theory, it could already be kind of covered, so I'll have to.
So don't worry about it.
So you're withdrawing 4?
Yeah, for now. Yeah.
Okay.
Because I was going to vote against it.
All right, 5.
All right,
Oh, we need a motion to
withdraw.
take no action, because it's his motion. We
Yeah.
can't withdraw his.
Motion to withdraw Savage Amendment 4.
We can't withdraw his
Yeah,
amendment.
just no action. You don't-
Can we?
Motion for no action on Savage.
No
Amendment.
action.
Second.
All in favor?
Aye.
Aye. Okay, and the Savage Amendment 5. No, this is the Arnett Amendment.
Not
I'm trying to
mine.
remember what it was.
Annual
This is
report
page 7.
required.
Oh, yeah, this is important. How do you, I cannot make this thing move.
You have it?
Come on, page 7. So this is a reporting requirement, because we have not been getting the annual requirements from reports from host compliance or any other reporting which was part of the original legislation. So this is to add an annual report required, and I did check with both Mr. Jakubiec, but more importantly with Mr. Manessa, to make sure that this wasn't adding an undue burden. And he said, no, he was just going to make host compliance do this report. So this is requiring that annually the council get a report that includes a map of the location of the short-term rental properties, statistics on the number of rentals, including new rental permits or other, you can see the A through E analysis of short-term rentals. And C is the really important one because, Brooks, I think it was you who told us that the number of rentals are increasing, but the number of days rented are decreasing, which I thought was important information.
Yeah, that was, and just a disclaimer on that, that was pulled for everything with an Annapolis address, so it did include information outside of the city because I didn't want to pay for the subscriber version of AirDNA.
Yeah.
I just created an account just to get some quick data references, but
So basically, the intent of this amendment is to add a section F that requires an annual report to us so that we know what's going on, because we get inquiries and messages of dissatisfaction or happiness with short-term rentals. So that was the point of this amendment. So I would move that we accept the Arnett Amendment 5 as Rules Committee 7.
Oh, no.
7.
No, 7. We're on
7. Is there a second?
second.
Okay, all in favor, please say aye.
Aye.
Aye. Okay. All right, I will entertain a motion to give a favorable recommendation for 03223 as amended.
So moved.
Second.
All in favor?
Aye.
Aye.
My God.
So I think this
Okay.
gives me a full understanding of why they call it sausage making. And so,
Yes, because I feel like I owe everybody an apology, staff, because it's grueling, grueling. So, okay. Do we have another piece of legislation
Yes,
in
we
front of us?
do.
City council nomination.
Yes. Which is 0324.
Correct.
Yes. Alderman Arnett, Alderman Savage, do you want to speak to this?
I'll be happy to. This is that we have on boards and commissions for a number of reasons, not applying any dereliction on anybody's part, but we have both vacancies and also long times to reappoint current members. And so the way the current code reads, a member remains on a board or commission after their term until such time as a replacement has been named for them. And this gives the city council, after a 6-month period, it continues the mayor's right to appoint and send to us for approval, but it also gives the city council the ability to nominate for either renewing the term of someone or nominating someone to go in there. So it gives us that nominating power if a vacancy of more than 6 months has occurred.
Alderman Savage?
Yeah, that's right. It's meant to be kind of a backup process in case we ever had a situation where nominations weren't being made, and it gives the council ability to step in if needed. It's not meant to abrogate the mayor's prerogative, but just be there in case it's needed.
Let me ask, does this take the mayor out of the process?
Yeah, that was gonna be my question. Because it says you do a nomination, but then who acts on the nomination?
No, it specifically doesn't. It says, while the mayor has primary authority to make the appointments, city council members may individually nominate candidates for boards, which we do now, and commissions. We suggest them to the mayor. The mayor selects, so if there's more than one or whatever, the mayor selects and sends it to the council for approval. So that remains in place, all of those.
Okay, so then you would do a nomination, it would go to the mayor for approval, and then back to city council?
Only if,
Yeah, any one of us can recommend somebody to be on the board, to fill a vacancy or to continue. But the mayor is the one who selects currently, but then the mayor sends it to us for approval. And all this is saying is after 6 months, the council can, in effect, select and approve. So we would
But see-
maintain that approval
See, I don't think,
process.
at least from my reading of it, a nomination is not the same thing as select and approve.
All right, I can clarify, I think. So right now, the code says that the mayor appoints. And
Well,
then the appointments.
it actually says it for different things. That was my other question, is that a lot of boards and commissions have their own sections, and how are those going to play with this general statement? Which also, I'm confused why it would be put in this part of the code versus in the part of the code that already deals with boards and commissions, because now you have to go look for this in the city council section versus having it with the other boards and commissions piece, which
I
is.
think that makes sense. I don't know.
My concerns were, one, I'm not sure I'd put it in the city council section personally. Two, have we cross-referenced this with all the other boards and commission sections that some of them have their own individual processes?
Presumably, I mean, this went through legal review, the law office, so I mean, those are the kind of questions that.
Well, I know, but those issues have been raised in the law office. I don't think they've made it up here, which is why I'm here. So from my perspective, it's in the wrong part of the code. Number two, I don't think it's been cross-referenced, because like I know my Arts and Public Places Commission has its own appointment process, and I'm not sure how this would fit into it. And three, I don't think it's not saying they have a nomination is the same thing as select and approve. So what you're really saying is that if there's a 6 months vacancy, you're gonna nominate, select, and approve, then that's what it should say. It shouldn't say nominate, because from my perspective, that leaves it in a fuzzy realm of, okay, you have a nomination, what do you do with it now?
I mean, I'm fine with changing it, I mean, but the goal is just, I think you understand what the goal is to provide that.
I completely get the
Yeah.
goal, and I'm fine with the goal. I'm not sure that it's accomplished, it's being accomplished.
So
I'm not clear on the-
recommend that we be given these, what I consider to be valid and important consideration. We postpone action on this until we can get some more further clarification from the Office of Law.
I think, so I think we want to make sure, one, that you don't have conflicting language, because if you have a general rule and then you've got like 6 or 7 other commissions that have a different thing and there's no reference to each other, it's like, well, which one does control? I want to make sure it's easy to find. And then I think there's also sort of a balance about, a question mark, at least for me, with, is the role purely to put a nomination out there, or are you stepping into more of a sort of executive function of actually appointing someone? So, and I wasn't sure which the goal was, because traditionally it was an executive function to appoint the people. If all you're doing is saying you're nominating people and they're still going back to the mayor to nominate, then I think it stays in that train. If you're saying you're nominating and then you're also essentially skipping the mayor, then that's a different legal analysis.
Well, I guess, so we've had a couple problems where, and I don't think these were always intentional, but we've had a problem where some of the board members have not been renewed, so they've been sitting on the boards technically with expired terms, and that, from testimony we've received, it's caused some consternation amongst board members in that situation. So that's one of the situations that I think we want to try to resolve by allowing the council to step in if those people are on expired terms for over 6 months. Because again, I guess if there's another way to get to that goal, I'm fine with it, but like, I don't want to have a mayor who, Gavin hasn't done this, but in large part, but if we have a mayor who refuses to make appointments, there needs to be some governmental process for good governance to have that check valve of, okay, if the mayor's refusing it, the council needs to be able to step in to have properly functioning governments and boards and commissions, right? I don't really care how we get to that point.
Okay, I mean, because that's what I was trying, when I read it, I wasn't sure which lane you were shifting to, and so it's sort of a different legal analysis if all of you're saying is we're going to nominate people versus we're going to sort of step into the executive role, which creates sort of a different legal issue. Because then we have to worry about overstepping executive boundaries.
So I think these are, for these reasons, which I accept as valid and need more perusal and guidance from the Office of Law, that's why I'm making a motion.
I staff, like, I don't know, a ton of boards and commissions.
Second.
So, yeah. But yeah, send it back and then we'll look at it.
Madam Chair, can I throw in one other request for your consideration associated with this?
Yeah, on this legislation?
Yeah. Because the staff report recommends essentially what would be an amendment. And so it might be good to get a request for that amendment in that we can review with this analysis at the same time.
Well, would you mind if we wait until the law department brings back their
'cause the whole thing might
recommendations,
change.
and
Okay,
then we'll take up the amendment
Makes
at
sense,
that
yeah.
time?
Correct.
Okay.
Good. Thank you for
All
those
right.
comments.
All right, and then R424. So yeah, let's get started on this one, the
All
comp
right.
plan.
So here I have,
I have my copy. Oh, I guess it's over there.
so I think that there's a struggle to figure out how we get this process initiated, and there's confusion between whether we're going to be making comments from the council as a committee of the whole and/or comments from council committees, groups of 3. And at the last meeting with the planning staff and the planning commission, both the director and members of the planning commission indicated a preference to have the council meet as a whole, so that they weren't running from committee to committee, getting different bits of information, which would then have to be rationalized before the council as a committee of the whole in any event. And so for me personally, I think that having the committee as a whole is the right way to go, but we need something to initiate that discussion. The director had indicated that he and his staff had taken a lot of notes from our first meeting of the whole, and that they were going to get back to us with that. At a subsequent committee meeting, which happened yesterday in Environmental Matters, we had asked that they give us their sense of what are the big issues, the big policy issues that we could debate. And I asked personally that they provide us what their sense of the big policy issues were. But they're asking us, before we have the next meeting, which is on the 28th, for each of us to submit to each other and to them our sense of what the issues are that need to be looked at. So we don't come to the meeting on the 28th and they're sort of just looking at each other and so forth.
Thank you, Alderman, for summarizing that for us. I think we have already asked our Assistant City Manager to reach out to all of our colleagues to ask that they send in and bring on the 28th any amendments or changes they would like to see in the comp plan, to give us an opportunity to hear them and do it in a kind of a round robin fashion so everybody gets to weigh in. And give, as you said, the planning staff some guidance on things that we would like to see different in the comp plan. The planning staff has been paying attention and making note of recommendations that they've heard already. And so I think we're going to start that meeting with their presentation, for lack of a better description, on what they've heard us say thus far, and what changes they see imminent because of those discussions. So hopefully that'll be, and we're hoping that the mayor's paying attention because we're really outlining that work session for what we need it to be so that we can actually get the comp plan in somewhat of a timely fashion. So that's our summary for the comp plan. It's pay attention to the next step, which will be the work session on the 28th. So anything else for the good of the order? Seeing nothing. Well, I do apologize for how laborious this meeting was, but it was important, and so we've gotten it done. So I'll entertain a motion. Alderwoman Pendel Charles, do you have anything you want to add?
No, thank you so much. I've enjoyed listening to the sausage, or watching the sausage being made, and listening to the grind. But no, it was interesting. I'm glad I stayed. Thank you so much.
All right. I'll entertain a motion.
So moved?
Second?
Now I want to stay.
Oh, he's going to stay. Okay. All in favor, please say aye. The meeting's adjourned. Thank you, everybody.